Hello everyone. So this is a video about fraud. So the Fraud Act 2006 is what defined that, particularly for England and Wales. So it repealed the previous crimes of deception, such as obtaining property by deception. That was as per the Theft Act 1968, Section 15. The Theft Act still stands, but that portion has been deleted. So our concept of fraud has been reformulated by the Fraud Act. Anyway, so the Fraud Act, it says one offence of fraud set out in Section 1 thereof, and there are three different means by which you can commit this crime. There's fraud by false representation, that's Section 2, fraud by failure to disclose, that's Section 3, and fraud by abuse of position, that's Section 4. You can face up to 10 years in the slammer for these offences. Having said that, it'd be very, very rare to get anything like 10 years. So the actus reus here is false representation. In a word, lying. So it could be a lie of omission though. So the mens rea here is saying something, making this representation which you know is false or you know might be false. So there's got to be dishonesty to this. Not quite sure how you could lie, but it not be dishonest. Anyway, so there's also got to be the your intention to obtain a pecuniary advantage or to cause loss to another person, even if you don't make a penny out of it yourself, or to cause someone risk of loss, even if you don't know they'll necessarily lose anything. If you just want to heighten the risk that they'll lose things, that could still be fraud. So the actus reus here is making the false representation. This could be a representation about what the law is, about what a fact is, claiming something as a fact when it's not, or indeed your own state of mind. Yes, I'm going to do this, or somebody else's state of mind. Oh, she's definitely not going to do that. R and King is a case about it, or Smith against Land and House Property Corporation. So the representation can be just saying it out loud, obviously in writing, but it could be implicit. It doesn't have to be express, as per Section 2.4. DPP and raise a case about this, as is Idris against DPP. So the court had to consider whether representation could be implicit solely through silence. That was in R against Waite. Well, a false representation is one which is false or is misleading, even if it's literally true. If it produces a bogus impression in somebody's mind, that's still a false representation. So Section 2.5, and it says what the representation can be, and here's a direct quotation: submitted in any form to any system or device designed to receive, convey or respond to communications with or without human intervention. So that's the end of it. So you can do it online, you can do it by email. So anyway, overcharging someone in R against Silverman, if you know that's not the price, but you deliberately charge them more than the set price, that would be a fraud. Or it could be if there's a relationship of trust and confidence, as in R against Jones. The mens rea here is being aware that the representation is untrue or might be untrue. That's as per Section 2.2b. So the mens rea here is dishonesty, Section 2.1a. R and Clark set that out again, and it was proved yet again in Ivy against Genting Casinos UK Limited. So the Theft Act, Section 2.1, is disapplied here. So if you have the intention to make a false representation with the objective of gaining something for yourself, or indeed inflicting some sort of loss on another person, or indeed heightening somebody's risk of loss, any of these things will be crimes as per Section 2.1b, 1 and 2. So so Section 5 talks about the loss. It could be pecuniary loss or loss of other goods, services and so forth. The loss could be temporary. It doesn't have to be permanent, as per Section 5.2b. So gain includes retaining what you already have. Loss includes not gaining what you would otherwise gain. So blackmail is part of this too. So the intention here must be to cause a gain or a loss by a representation, as in by what you say. So there's R against Zuriuni, 2008, a case about this, where it talked about oblique intention. So fraud by failure to disclose. Sometimes you're a duty to say things, right, to reveal information. So the actus reus here is when you're under a legal duty to offer certain information. and you fail to disclose the information that you're obliged to disclose. So the mens rea here is dishonesty, as per section 3A, and the intention by failing to disclose that information to make a gain for yourself, cause a loss to another, or indeed expose another to a risk of loss. So the actus reus here, remember, when you have a legal duty to disclose in some situations, when you're asked whatever, it might be because of a fiduciary relationship or an insurance policy or something. And so this legal duty arises in various situations. There's a Law Commission's report on fraud, came out in 2002, talked about certain statutory duties, transactions of ubere mai fide, as in of the uttermost good faith. Some duties are implied by custom in certain trades or markets. This is the way we always do it, dealing whatever it is, or the fiduciary duties, as I talked about if you're a trustee or something. So the actus reus here is not disclosing the information that you are legally bound to disclose. The mens rea here is dishonesty. So you're intentionally not disclosing the information with the aim of making a gain for yourself, causing a loss to another, or indeed increasing somebody else's risk of loss. So there's a fraud by abuse of position as per section 4. Now the actus reus here is the defendant must be in a position which obliges him to safeguard someone's financial interests, and at the very least not to act at the detriment of that other person's financial interest as per section 4.1a. Like a trustee would be an obvious example, or a solicitor or an accountant. You must be abusing that position as per section 4.1b. So the mens rea here is dishonesty, as under section 4.1b, and your intention by misusing your position is to gain for yourself, or indeed to cause a loss to another, or indeed to increase another person's risk of loss. And remember, it's probably becoming very familiar to you. That's as per section 4.1c, 1 and 2. So the actus reus here, the defendant must be in a position which obliges him to look after somebody else's financial interests, to keep the money saved, to try and make whatever the dividends grow or something. So doing this for another. And that's as per section 4.1a. So what sort of position would these be? These are fiduciary positions. As I say, trustee, looking after the money of a beneficiary, company director, looking after the company, some professionals doing it for their clients, as I say, like solicitors and accountants, bankers and so forth. R and Marshall was a case where they said, well, what if you're in a family situation? What if you're a volunteer? What if you're an employee? And R against Valjuves and another looked at this, and they said it's not only strictly fiduciary positions, it's anything which is kindred to a fiduciary obligation is the same. But it's up to the judge to decide whether in this case this relationship exists, this sort of position of trust. So the law is still developmental here. We're still in a grey area. Okay, so the person must be abusing that position as per section 4.1b. And so what is abuse of a position? Well, R against Pennock 2014 considered this case, and this is what the judge ruled. Using incorrectly or putting to improper use the position in a manner contrary to the expectation arising from that position. Close quotation. So the abuse of position can be by doing something, when a positive act. That doesn't mean it's a morally good act, but it means it requires real action, or indeed a negative action, as in not doing something you're supposed to do by omission. You didn't do something, you just were torpid about it. You failed to perform your duties, and that could also be a fraud. So this is one of the few crimes which can be committed by omission, by refraining from doing something, as well as most of the time doing something is committing fraud. So the mens rea here is dishonesty, as per section 4.1b, and you must have the intention to misuse your position with the aim of gaining something for yourself, for another person, or indeed causing some loss to another person, or indeed increasing the loss to another person. Increasing the risk of loss, I should say, as per section 4.1c1. Okay, and making off without payment, well, that's as per section 3 of the Theft Act 1978, from a restaurant, from a petrol station, something like that. So Edwards against Deere 1976 considered this about going to a petrol station. Okay, so filling up your car with petrol, and then when you might go in there with the intention to pay, then you change your mind and you have the intention to skedaddle without paying for it, at that point the dishonest intention is formed. So you've got the mens rea, okay, because the petrol belongs to another, you haven't paid for it. So Section 3 of the Theft Act 1978 says, subject to the subsection below, a person who, knowing that payment on the spot for any goods supplied or service done is required or expected from him, dishonestly makes off without having paid as required or expected, and with intent to avoid payment of the amount due, shall be guilty of an offence. For the purpose of this section, payment on the spot includes payment at the time of collecting goods on which work has been done or in respect of the service has been provided. Close quotation. That's it. Okay. So you're wanting to avoid payment, not to come back and pay for it later. No. Okay. So making off without payment. The actus reus here is running away, driving away without paying for it. That's crucial that you didn't pay for it, and you're required or expected to pay that at that time. It's not a situation where you get this good a service. We always know you pay a month later, and it's for goods or services. Well, what else would you buy? So the mens rea here is being aware the payment at that place is obligatory. There's also a requirement of dishonesty here, not just absent-mindedness. Once wandered out of a restaurant not realising, came back the next day and they told me. They're quite decent about it. And you must have the objective of never paying for it. And then that makes up the mens rea. So making off, that was found in R and McDavitt, and R against Aziz without payment. Well, R against Hammond defined that as required or expected. Troughton against the Metropolitan Police Commissioner. So this is for goods and services. So the mens rea here is when you're cognizant that payment at that place and at that time is obligatory. R against Brooks, and Brooks is a case in point. There must be dishonesty there, and you must be intending to evade ever paying for it. R against Allen says that means paying ever. Okay, if you intend to come back later and pay for it, it's not theft. Okay, so I hope you found that a little bit useful. Toodaloo.